All right, boys and girls. Todd Vandermite here for Freedom Steel, former NRA contract lobbyist and Illinois gun law guru. So, this is going to be part two of me chopping up and going through the brief filed by Naperville's pro bono anti gun attorneys over why their ordinance on banning the sale of semi automatic rifles is constitutional. So, without further ado, let's get into this, and I'll have something to say about it at the end. Even assuming plaintiffs could meet their burden of demonstrating that assault rifles are suited for self-defense, they are common and are commonly used for that purpose, Naperville's ordinance does not ban, prohibit, or prevent anyone from keeping or bearing arms for self-defense in the home. Irrelevant. It's not our burden, generally speaking, except the burden that we're likely to prevail for purposes of an injunction. We have to be likely to prevail on the merits of the claim in order to succeed on an injunction. But what you're saying here is the burden is on us to prove this self-defense claim that you guys have drummed up out of whole cloth. That's empty formalistic reasoning of the highest order. No, we don't have to do that. Let's see, the ordinance that merely regulates commercial sale of goods within the borders, a situation wholly unrelated to the possession of handguns for self-defense, and one within the common and ordinary power of government, except it deals with an enumerated right, as dealt with in the Illinois Association of Firearms Retailers. They specifically cited that. The Second Amendment never mentions sales of firearms or assault weapons. Therefore, by implication, the plain text of the Second Amendment does not cover it. Again, you guys haven't followed Izell. You guys haven't followed Illinois Association of Firearm Retailers. You guys got nothing. You guys have zero. Nothing. And you're trying to rewrite the text of the Second Amendment to say that it needs to read like a statute of today for possession, sales, recreational use, acquisitions, dispositions, the whole nine yards. That is not how this goes. I mean, based on your interpretation, then the First Amendment should have talked about the internet, television, and radio, or that's not covered. Inferring that selling assault weapons is protected by language concerning the individual right to possess and carry handguns would expand the meaning of the Second Amendment well past the breaking point. No, it's not about just possessing and carrying handguns. Heller, in common use, which means weapons that were not in existence in the 18th century, are to be protected. Their possession. How do you possess if you don't acquire? How do you acquire if there's nowhere to buy them from or allow people to sell them? The plain text does not cover conduct that has nothing to do with keeping or bearing arms. This goes against Izell 1 and 2 because both of those specifically talked about the right to train and the right to acquire. There was nothing, doesn't say training is necessarily covered in the actual text of the Second Amendment, but training to remain proficient in arms is part of the colloquial right. That's just it. Simply put, no court, pre or post Bruin, has found the plain text of the Second Amendment covers the commercial sale of any weapons because it does not. Wrong. Nope. Once again, you guys have pole vaulted straight to potato. Guys, I'm amazed I'm only on my first whiskey with the absolute stupidity that is in this brief. I wonder if some paralegal or first-year law clerk didn't write this stuff for there ought to be sanctions for this bullpucky. There just really ought to be. All right. Historically, governments have retained substantial latitude in enacting restrictions on certain weapons deemed to be susceptible to criminal misuse and to pose significant dangers to the public, from trap guns to certain knives, blunt objects, and pistols, provided that law-abiding citizens retained access to traditional arms for effective self-defense. You get it wrong here, too. Trap guns, they're not talking about skeet, trap, stuff like that. I think what they're talking about are spring guns, where they're set up where somebody steps on a tripwire or a spring-loaded trap that then sets off the firearm, and it's completely indiscriminate. It doesn't distinguish between a burglar or a kid just in the wrong place at the wrong time. Certain knives, we're seeing this. David Copeland even wrote a piece about this. They're going to try to bootstrap up regulations on Bowie knives and the like in order to try to get that twin that they need to say, oh, see, they wouldn't allow Bowie knives, blunt objects and pistols, but these things are all starting to be challenged. Well, there's a challenge to nunchucks. You saw the challenge to stun guns, that arms wasn't defined as firearms. It was defined as arms. And therefore, it covers a much broader. Actually, the definition of arms talks about offensive or defensive to include armor. So we'll probably have a tangle over body armor at some point down the road here. And retain the access to traditional arms for effective self-defense. But they tried this argument in Chicago and in Heller, where they said, well, because we didn't ban everything, we left them something. That dog don't hunt. The Supreme Court dealt with that argument. Let's see. It does not police powers to address public safety. Indeed, the Supreme Court has recognized that governments have had the power to regulate dangerous or unusual weapons. Okay. Here is another piece of legal malpractice and malfeasance. The term is dangerous and unusual. By inserting or in brackets, this is an overt act on their part. This is not some casual slip. They edited the actual text from Heller. This is not. And they're trying to do that all over the place. They're trying to make it dangerous or unusual. We saw that in the original Friedman stuff. We saw that in other stuff. They have been trying to do this for some time. And they're going to get called on it. Let's see. Naperville's ordinance is therefore consistent with local government's general powers to regulate conduct within its borders. You want to regulate zoning? We'll give you that, as long as you don't foreclose, 99% of the land. But no. First Amendment protection of tattoos of speech does not mean that cities cannot regulate tattoo parlors with taxes, health regulations, or nuisance ordinances. Yes, they cannot. They can't regulate for nuisance ordinances, and taxes on that might be a stretch, guys. Health regulations will give them. They can do that, but again, they're restricted to zoning and a couple other things. So, bad comparison. The ordinance is consistent with common historical regulations of dangerous or unusual weapons in American history. Again, they are trying to rewrite the standard. The standard was dangerous and unusual. And now here they're throwing in this new phrase, unusually dangerous weapons. Doesn't work. Not going to happen. Your guys' reframing of what Heller said and what the test actually is BS. I hope this judge throws sanctions down. Assault weapons are an example of a dramatic technological change. Okay, What about Quintano? There you had stun guns. Somebody tell me that the founding fathers envisioned electrical discharged weapons such as a stun gun. They didn't even have cattle prods back then. And yet the Supreme Court in 2016 found that they were protected arms. They're truly a 20th century invention and novelty, and they are protected. Doesn't matter how big a technological change there was. They are protected. In 1791, virtually all firearms were single shot, and guns capable of firing more than a single round could be best described as exotic. Wilson's dead letter law. And what the guns were in 1791 is not the test. As Justice Scalia said, some have made the argument bordering on the frivolous, that only those arms in existence in the 18th century. That's not the test. He said just the opposite. They are protected. Modern firearms are protected. To the extent that there were high-capacity firearms, they were regarded as weapons for the military or law enforcement. Irrelevant. You guys are trying to bring another test into this. Irrelevant. Assault weapons like those covered by Naperville's ordinance also implicate societal concerns that have no founding era precedent. No. Now you're interest balancing. So you were sitting here trying to discount what Heller actually said, and you're trying to go back to the test that was developed post-Heller and McDonald that used interest balancing. You're wrong on both counts here. Page 23 to 28, guys. I'm amazed we made it this far. Here, the ordinance's burden is minimal. There is no shortage of widely available firearms that Naperville citizens can purchase in Naperville for self-defense. The ordinance only prohibits the sale of certain assault rifles. Firearms that are compliant with the ordinance are widely available, and firearm owners who currently use the non-compliant assault rifles are able to possess and use those weapons in a lawful manner. Owners and future owners who wish to purchase an assault rifle will simply not be able to purchase those weapons within the Naperville city limits. Minimal burden. Now you're doing this interest balancing approach all over again. And on top of that, you're sitting here going directly against what Ezell said, to where people could sit there and go to some other location. Well, they keep trying to go back to this interest balancing approach, and it's going to be interesting to see what the courts say here. Let's go on. The law has no effect whatsoever on which firearms may be owned. It's not about ownership. You guys keep trying to make this about ownership, possession, and you keep citing here. You cited Duncan. It's dead letter law. Well, again, let's see. More recently, the 20th century ban on machine guns continued the historical tradition of restricting unusually dangerous weapons unneeded for legitimate self-defense. It's not up to you to decide what we need or don't need for self-defense, number one. Number two, you're trying to bootstrap this unusually dangerous argument. That's not the criteria. The criteria is dangerous and unusual. Every firearm can be dangerous, but dangerous and unusual. That's the issue. Supreme Court confirmed in Heller that the Second Amendment does not prevent the prohibition of private paramilitary organizations. That was Presser, and it was actually an Illinois case that talked about a march of a paramilitary organization. But that's not what we're talking here. Trying to drag in a paramilitary type organization has absolutely nothing to do with the case at hand. It just doesn't. Like laws prohibiting unusually dangerous weapons, laws restricting paramilitary organizations, impose practical limits on firepower for armed self-defense. No, it doesn't. They simply said that a group of armed individuals had no right to march down the street. They just didn't under the old, under that thing. So here you're trying to sit there and say that an armed mob is akin to law-abiding citizens. Assault weapons, like the weapons prohibited in other eras, are suited to unlawful purposes, are not needed for legitimate self-defense, impose significant risk to public safety and security. You're right back. You're right back to interest balancing. You guys are just stuck on this merry-go-round about interest balancing and trying to bootstrap interest balancing in any, bring it in any way, shape, or form that you can. That's all you're trying to do here. The ordinance's prohibition on the commercial sale of assault rifles is justified by similar public safety interests that have historically been understood to justify the exercise of police powers in regulating possession. Not anymore. Not under New York. New York, you have to find a historical reference that such was in the tradition and history in the regulation of arms in our country. That's on you. That's not, modern firearms. It doesn't exist. This stuff is so thin, and you keep trying to justify it by similar public safety interests. No. Whatever you want to claim about that is out the window. There is no interest balancing approach. Usage and storage of firearms okay. Historically been understood to justify the exercise of police powers in regulating the possession, use, and storage of firearms. Further, assault rifles are analogous to dangerous weapons that have historically been restricted without infringing upon the core right. Okay, storage of firearms. You're trying to go back to this Northampton ordinance and rule of law that they tried to bring in New York and was summarily rejected. No. You guys, we're talking about a very simple concept. What were the regulations on the sale of firearms in 1791? And even if you jump to 1865, 1868, what did you have then? So here they're beefing about their briefing schedule. They wanted a long briefing schedule, much like California wanted, to sit there and bring in experts and do all this research. And the court did not accept your briefing schedule. You're right, they didn't. The court felt this could be briefed out, and here you go. They are setting this up for an appealable issue. That's all they're doing here. They're trying to set this up for an appealable issue that they weren't given enough time. Well, Naperville has done its best to marshal a historical record on the accelerated timetable and has provided numerous citations to learn treatises in this brief. It has been unable to conduct a primary source research or to retain and disclose an expert. They are trying to do what Benitez would not let them do out in California. They are trying to bootstrap up a appealable issue for more time. If this briefing results in the court issuing a final ruling on the merits, the lack of formal discovery will have deprived parties of a full and fair opportunity to ventilate the issues involved in the post-Bruin analysis. Again, they're all but admitting it. They are trying to set up an appealable error so that they can get a reversal on appeal of the injunction. For the conclusion, this court should deny plaintiff's motion for temporary restraining order and preliminary injunction. Yeah, no. This is thin. This is extremely thin, and it's doing is citing dead letter law. They completely omit Ezell. They omit Illinois Association of Firearm Retailers. They lie about what the court has said in Heller, and that there are no cases on the sales of firearms. No. They're getting pro bono legal help on this. It looks like they're getting exactly what they paid for. So, guys, with that, yeah, I didn't even get through my entire whiskey with this because I've been talking so much, but holy smokes. We're seeing this. This is the playbook we're seeing. We're seeing this in California. We're seeing this in the Maryland case. We're seeing this play. They played some of these things out in Oregon, Rhode Island, and a couple other places. This is their playbook. They have shown us their playbook. That's all that matters. And we have, it's an open book test, and we now know what we have to rebut. And it's funny that they're all following the same kind of stuff throughout the country. So, with that, hope you've enjoyed this commentary on the city of Naperville's brief as to why their ban on sales of modern magazine-fed rifles is permissible. With all that, so guys, please like, subscribe, do all that, copy and paste our link and put it on the forums and all the places you hang out and talk with your gun buddies. We really appreciate it. You guys have gotten us past 2,000 subscribers. As of today, we've gotten past the 4,000 hours with YouTube, so we're starting that whole process, and hopefully this thing just keeps growing by leaps and bounds, so we can just keep submitting and sharing with you these nuggets to deconstruct what the anti-gunners have. And these are the guys that defended Friedman, and this is the best they got right now. And they will probably join in at whatever state ban comes in. They will probably be helping out Kwame Raoul's office. And if this is the best they got, I'd send my 19-year-old in there to argue against these guys because they just don't have it. Nothing in here scares me. I'm actually tickled that they're this flippin' stupid. So, with that, guys, again, please like, subscribe, share it with all your friends, share it on social media, pass the word around, and as always, frag out.